5 seconds to go. Start. In Jagjit Singh Supra, a three judges bench of this court has observed that the power to grant bail under section 439 CRPC is of wide amplitude, and the High Court or a Sessions Court, as the case may be, is bestowed with considerable discretion while deciding an application for bail. But this discretion is not unfettered. The order passed must reflect due application of judicial mind following well established principles of law. In ordinary course, courts would be slow to interfere with the order where bail has been granted by the courts below. But if it is found that such an order is illegal or perverse or based upon utterly irrelevant material, the appellate court would be well within its power to set aside and cancel the bail. Keeping in mind the aforesaid parameters, we may now proceed to examine the pleas taken by the parties so as to decide as to whether the impugned orders can be sustained or not. On a careful consideration of the entire records, we are inclined to agree with submission made by learned counsel for the appellant complainant that the impugned orders are unjustified and suffer from grave infirmity. The primary factor that has swayed the learned single judge of the High Court in granting bail to the accused Waseem is that even though the prosecution version is that 11 accused persons had assaulted the appellant complainant and members of his family on indiscriminate firing taking place, only 3 persons had sustained injuries and 2 had expired on the side of the appellant complainant. At the same time, serious injuries were also received on the side of the accused, which could not be explained by the prosecution. In the case of the accused Nazim, the High Court observed that there was no distinction between the role attributed to him and the co-accused Waseem, and that the injuries suffered on the side of the respondent had not been explained by the prosecution. The High Court has also gone to observe that the investigation conducted by the police was one-sided and the case set up by the accused side was ignored. In the case of Aslam, his bail application was allowed and learned single judge observed that there is a cross version of the incident inasmuch as the accused side had also received serious injuries which were not satisfactorily explained by the prosecution. In the case of Abu Bakr, noting that the co-accused Aslam was granted bail by a coordinate bench and the case of Abu Bakr was similar to that of Aslam, he was granted the benefit of bail on grounds of parity. In our opinion, the High Court has completely lost sight of the principles that conventionally govern a court's discretion at the time of deciding whether bail ought to be granted or not. The High Court has ignored the fact that the appellant complainant has stuck to his version as recorded in the FIR, and that even after entering the witness box, the appellant complainant and 3 eyewitnesses have specified the roles of the accused respondents in the entire incident. The High Court has also overlooked the fact that the respondents have previous criminal history details whereof have been furnished by the counsel for the state of UP. It is worthwhile to note that the accused Nazim was granted bail in FIR number 214 of 2016 on 10th January 2017, and while on bail he is alleged to have committed a double murder of the 2 sons of the appellant complainant. To top it all, while on bail, there have been allegations that three of the accused respondents herein have threatened one of the key eyewitnesses, Abdullah PW2, in open court, thrashed him, and threatened to kill him in the court premises. Stop.